Hello and welcome to another episode of Talking Politics on The Hindu's YouTube channel. I'm Nistula Hebbar, political editor of The Hindu, and I will be your host taking you through the big stories making the headlines in domestic politics. Now this week, the Assam Legislative Assembly passed the Assam Compulsory Registration of Muslim Marriages and Divorces Bill of 2024, a proposed law that the state government claims will prevent child marriage and also check polygamy in the Muslim community in the state. This is a law which provoked controversy with the BJP-led government, as I said, stating that it was working to safeguard the rights of Muslim women and children, while the opposition is claiming that it is yet another effort by a right-wing government at a heavy-handed interference in the personal law of Muslims. Let's first look at what the bill actually does. Now, the passage of the bill was accompanied by the repealing of the Muslim Marriage and Divorce Registration Act of 1935, which, largely in line with the Muslim personal law, authorized the state to grant licenses to any person who's a Muslim to register Muslim marriages and divorces, namely the Qazi who does these things and who solemnizes such events. And at the last count, there were around 95 Qazis across the state who were authorized to perform such registrations, customary marriage and the registration with the Qazi. So right off the bat, the new bill seeks to remove the authority of the Qazi in registering these marriages. Every Muslim couple in the state is to register their marriage with the sub-registrar of the area, who is the only recognized authority for doing so. Thus, the Qazi is not the recognized authority anymore. Marriages thus registered have to be between two people where the bride is above 18 years of age and the groom over 21, with free consent from both sides. One of the wedding party is to be a resident of that area for at least 30 days before giving notice that such a marriage will take place to the sub-registrar. This notice will be accompanied with documents and proof of identity and age to the sub-registrar. The 30-day notice period can be used by anybody to raise objections against such a union and for the sub-registrar to examine such objections. For example, if it is found that somebody realizes that the age certificate which has been provided by the bride's family to the sub-registrar is fake, it is showing the bride's age far more than it is, or some such thing, or that the groom has a previously existing marital union, etc. All of these objections can be raised with the sub-registrar within that 30-day period. Now, if any information furnished is found to be incorrect or fabricated, the sub-registrar has to act and get in touch with higher authorities for prosecution in the case. Now, if the sub-registrar does not act, he is also liable to fines and even imprisonment of up to a year. Now, many of these provisions, including this 30-day notice, etc., basically your modern version of posting the bonds, it's akin to the Special Marriages Act, which is held across India, which facilitates the registration of interfaith marriages, not customary sort of intra-faith unions, but where the bride and groom belong to different faiths. Now, there is something called a Special Marriages Act, and that is used by couples who are marrying across faiths. Opposition MPs have said that the rather complicated requirements for marriage registration, even in order to circumvent child marriage, could have been done by suitable amendments to the earlier Act of 1935, which I had told you earlier, had been repealed before this bill had been put to vote. But Chief Minister Himanta Biswa Sarma of Assam said that the issue wasn't just of registration, but of removing the role of the Qazi altogether. Since under Muslim personal law, marriage can take place on puberty, which is in a uniform way taken as, say, 15 years of age in a woman. Hence, below the legal age of consent under the Indian law. When such matters came up in court in the past, where, people went to court over child marriage accusations, etc., the Qazi said that under this act, which is more akin to the Muslim personal law, Qazis can officiate marriages of girls who've hit puberty or children who've hit puberty, so they cannot be prosecuted, and therefore they don't get prosecuted, and which is why Himanta Biswa Sarma said he felt it was required that the old act be repealed and this new act be brought in, which has very little to do with Muslim personal law and a lot more to do with the Special Marriages Act. He also gave examples of lack of prosecutions possible for child marriage through his government's crackdown on child marriage, which he did last year. Around 4,000 such marriages cases there came up out of that crackdown, and in many cases, Qazis used this particular loophole or clause in the Muslim personal law and the 1935 Act for not getting punished for officiating over child marriages. So this issue on the whole has raised much controversy, with Muslim groups alleging that it was an interference into their personal law in a backhanded way by the government. The government is asserting that the principles of gender justice and child protection are its defense. Both arguments are persuasive, but the politics over the issue pertains to the lack of trust between the BJP-led government's intent and the Muslim community in Assam. With Mr. Sarma's frequent comments on demographic changes, on, against Mia Muslims or Bangladeshi Muslims, as, Mia Muslims actually are, and allegations like flood jihad, etc. All of these things had already created some bad blood. And the Muslim community feels that this particular intervention as well, it has less to do with any genuine altruistic desire to kind of reform the situation for women in the Muslim community, but to just irritate the Muslim community and basically strip them of their customary rights. Muslim community has also not been co-opted in any way into the BJP's political framework as such in the state, and that is something that is actually creating the controversy. Now, the aim of the bill is to curb child marriage and polygamy, and it's laudable in my view, and no right-thinking person can oppose it. The problem here in this case only arises when you perceive the quarters from where this bill originates as being opposed to Muslims having rights to their personal law. Now, there needs to be a bridge between the two, built through communication and trust, because BJP is a party which has been talking about a uniform civil code. Of course, it has also been mentioned in the Constitution of India, in the Directive Principles of State Policy, but it is an ideological aim of the BJP, so the Muslim community has to be brought on board for this reform also to take place. There must be enough right-thinking people within every community who would want the end to child marriage and the end to polygamy. Now, with this bill, it may not be far that Assam may see a state-specific uniform civil code like the one in Uttarakhand. Now, that too will require channels of trust between the state, including the Muslim and indigenous communities. Indigenous communities, it has already been declared, are likely to be kept out of the purview of the Uniform Civil Code. Now, all of these channels of communication will be required later if the Assam government wants to bring in a UCC, and for that to be acceptable and widely acceptable, because the success of any law or any coda is to basically be acceptable across sections of society. It won't be a bad idea for Himanta Biswa Sarma to deploy his legendary political savvy and powers of communication to start with this bill, beginning with selling it to the constituency it is actually aimed at, the Muslim women of the state and the rest of the Muslim community. With this, we come to the end of this episode of Talking Politics. I shall see you next week. Thank you so much for watching.